I think there are two topics that we are really discussing today, and both of them are actually of significant importance, considering the evolving sort of changes that you are seeing across different countries, both in terms of the OECD making certain policy-related changes, in terms of the BEPS, the whole BEPS agenda coming in onto place. At the same time, you're having new age issues, whether in the form of e-commerce, whether in the form of other internet-related issues which are coming in, which also makes people think as to how would you look at the concept of permanent establishment, considering the evolving changes in the way the market has been functioning, and also how OECD has been approaching some of these issues. We have with us today two what I would call two eminent personalities in the sphere of international taxation. We have Professor Richard VANN, who is the Challis Professor of Law at the University of Sydney. Professor VANN has worked as a counsel for taxation in the legal department of the IMF, along with and also the NIS program, the Fiscal Affairs Division at the OECD. He is also a member of the. He was a member of the Permanent Scientific Committee of IFA until last year, and is also an international research fellow of the Center for Business Taxation at the State School of Business at Oxford University. Professor VANN would be talking about the future of permanent establishment and attribution rules in tax treaties. Subsequently, we'll also have Professor Pistone, who will also be speaking about the issues relating to evolving interpretation on tax treaties. Professor Pistone holds the Jean Monnet and Personam Chair in European Tax Law and Policy at the Vienna University of Economics, Austria, and is also the Associate Professor of Tax Law at the University of Salerno in Italy. He has, over the last 15 years, lectured extensively on issues of European and international tax law at several universities. And he's been currently invited to present his views in meetings organized by the European Commission, the ECJ, and also the OECD. With that, let me just hand over the floor to Professor VANN, who will be speaking on the future of permanent establishment and attribution rules in tax treaties. Over to you, Professor.
Thank you. Thank you for inviting me here. This seminar was organised in part of the IBFD project on the global tax treaty commentaries. And what I'm going to try and do is give you a bit of a flavour of how those commentaries may be different from other things that are out there on tax treaties. And that's reflected in the title. It's not a commentary just on what is. It's really about where we came from and where we're going to. So whenever I talk, my students will tell you that I never vary from this. I start with history and policy. Okay? That's where did we come from, what are we trying to achieve? And then you can start thinking about what's wrong with current rules, how they might be changed. I think everyone agrees there are problems in the current rules about what is the threshold for before a country can tax business income, and then how you actually go about measuring the income that you can tax. And so that's what I'm going to talk about. I'll talk a bit about the history of the permanent establishment threshold firstly, and then I'll talk about the measurement issue, what I call the separate entity arm's length principle. It's often just called the arm's length principle, but the separate entity bit of it's quite important, as we'll see. Then I'll talk about why do we use these concepts for taxing business profits? What are we trying to achieve? Why don't we just tax everyone in the world on their business income if they're selling to people in India, for example? Why do we have a different rule? And then, having done that, I'll talk a bit about the theory of the firm, which is why do we have multinational enterprises? Why don't we just have one big marketplace like you have all over in Mumbai, where you go and there's just all these people selling everything, and there's no big firm, there's just all these individuals dealing with each other directly. So why do we have multinationals in the first place? And that's what the theory of the firm explains. So once we know what we're trying to achieve and what we're dealing with, which is these multinational firms, then you can start seeing why the rules are under tension. And I'll go through the kinds of tensions that have arisen in recent times and look at two particular OECD projects, the attribution of profits to permanent establishments project, which took them a decade, more than a decade, from the late 90s to 2010, and then more recently the base erosion and profit shifting project. And I mean, I think we all understand that everyone, including India, is unhappy with the current rules. It's very hard to work out where you're going to go from there, and that's what I'll talk about. Some possible directions. One direction would be revision, not replacement of the threshold, and I think that's where we're likely to go. I don't think we're going to see a big tax or some complete change in the international system. So that's the threshold. The threshold will remain, but the question will be what is the threshold, and I'll talk a bit about that. And then the measurement issue, and I think there we're going to see a move away from transactions to profit methods much more significantly. Some would say that's a move to form reapportionment. I don't think it is, but it's going to be a different method of measuring the profits. But then there will be the question, will it be enough? And I think for countries like India, a lot of people say, no, it's not enough. We want more. But that's the political debate that's going to play out in the next period of time. So let's go back into history a bit about where this permanent establishment concept comes from. Everyone always says, which is quite accurate, that it originally came out of German, or in fact Prussian, tax law in the 19th century. So we're going back a long while. This concept's been around. It wasn't invented by the OECD. It wasn't invented by the League of Nations. It has a longer history. And even in other countries like the UK, in other areas, it's not the issue you're looking at in tax is not just a tax issue. Okay, it comes up in lots of areas. When do your courts have jurisdictions over foreign businesses? If you want to sue them in India, when can you sue them in India? And you'll find in the UK, and I suspect in India as well, that there's a very similar test to a permanent establishment threshold about before you can sue a business here, they've got to have some operations here, they've got to be here in some sense. So it's not just a tax issue, it also comes up for foreign direct investment. You have rules in India about people investing here. Well, when are you going to apply those rules? Do you apply those rules if someone's just selling something to India? No, you don't usually apply those rules. You wait till they actually establish themselves here. And that's what the PE concept was about, and I'll come back to why we have it a bit more, but it was about when is the business here? Does it have a sufficient presence here that's going to justify taxation? It went more or less from German tax law into tax treaties. The very earliest treaties in the late 19th century adopted the same concept, and it's remained a very durable threshold for taxing business profits. And I think you can't overlook that. We can all identify flaws in the concept, but the fact that it's been around for so long and has endured does suggest that it's got something behind it that we don't want to lose sight of. And so the League of Nations then adopted it out of the early treaties. The OECD continued with it. So it's not as though it's just sort of been foisted on us in recent times. The UN then adopted it when it produced its model. So the India, in particular, when the UN was drafting its model originally, wanted to start from scratch, but all the developed countries and developing countries decided, no, we're not going to start from scratch. We'll look at OECD and then we'll change what we don't like in OECD, but we're not going to just start completely with a bare canvas. It's significant to note that in the original League of Nations draft, the definition also included subsidiaries. Okay, and this is something that people comment on, but I don't think they pick up the significance of, and it's the issue that I'll say a bit about. I think that when the concept was developed, and for many years subsequently, subsidiaries were very uncommon. Okay, businesses, DuPont was the first business back in the early 1900s which divisionalised, actually had separate divisions. They didn't have subsidiaries, they had divisions. Okay, the idea of having subsidiaries is very much a modern phenomenon. In fact, in company law in a number of countries, you couldn't have a subsidiary. A company couldn't own another company. So there were a number of barriers, and businesses sort of formed companies and just one company. And in that context, the PE threshold sort of made some sense. It's sort of, they weren't going to split their activities up amongst a whole lot of companies, all doing a little bit, none of which amounts to a permanent establishment. They either came with one company and set up here, or they didn't. So that the kinds of modern tax plan of splitting of activities and all that kind of stuff just wasn't feasible for a number of reasons in those times. It wasn't how they did business. But that inclusion of subsidiaries in the original draft, I think, indicates that what you were looking at was the group and the group's presence in the country, not each individual company's presence in the country. We're just saying, to what extent is this group present in our country? And we just treat subsidiaries, PEs, all as part of that measurement. What's happened with the separate entity bit of the separate entity arm's length principle, that has moved to an entity by entity by entity concept. And that's obviously going to start creating pressures, and that's where I think a lot of the pressures come from. So the history, when you look at the history, it was just identifying when a business had a significant presence in a country. You didn't get all the kind of modern day problems of fragmentation of multiple subsidiaries and multiple entities operating in a country and the things that they do. And so it's not surprising that the modern context, the concept, the specifics of the concept may not work very well. It doesn't mean the basic concept is flawed, it just means the application of it is a problem, because it doesn't take account of a whole lot of separate companies. It doesn't look at them as a group, it just looks at each individual company and its presence in a country. So that's sort of a bit about the history. The separate entity arm's length principle, again, as is fairly well known and often referred to, was a relative latecomer. I mean, we think the 1930s was a long while ago, but international tax problems had been around, particularly in Central Europe, for 60 or 70 years by then. And one thing they've never been able to adequately resolve amongst themselves, well, once we've identified that you're present in 3 countries, how do we actually work out how much each country is going to be able to tax? And the League of Nations couldn't come to a resolution of this in the 1920s. The Rockefeller Foundation gave a lot of money to the League of Nations, and a lucky young person called Mitchell B. Carroll, who subsequently became very well known, but at this stage was quite young, was sent on a trip around the world for 3 years okay, to find out how they did it. So he went to many countries and produced a 5-volume report in the early 1930s, which set out actually how countries did tax business profits, and they were widely varied. You can go and read them now. You'll see every possibility under the sun pretty well was used. They agreed that we're going to adopt this separate entity arm's length principle. It was one that was used by a number of countries, not universally. Lots of countries use empirical or formulary methods, which were the other 2 main methods that Carroll identified. Empirical is just some rough proxy of where you say, oh well, 10% of your sales income is kind of a reasonable measurement of the profit you're likely to be making. Formulary is where you work out formulary apportionment, you work out the global profits, and then you allocate it based on some appropriate formula of employees, assets, payroll assets and sales is the typical one. So they chose the League of Nations, the separate entity arm's length principle. But if you go and read Carroll's report, you'll see they didn't agree on what that was. It's volume 4 of the 5-volume report that he produced. It's clear that most of the countries wanted to use what Carroll called the sale between independents approach. So if you had a head office who manufactured a branch which sold the products that were manufactured, then effectively the manufacturing profit was in head office, the selling profit was in the permanent establishment, and you just used a wholesale number to allocate sort of between a manufacturer and a wholesale number to allocate between the two of them. Carroll didn't like that. Okay, it's what most countries who use this approach did. They effectively dictated the kinds of transactions that they would assume were occurring. There was no idea of transactional freedom. They just said, oh, if you've got manufacturer there, sales office there, we're going to allocate the manufacturing profit there and the sales profit there. No functions, assets, risks, none of all that stuff that we have nowadays. They just did it in a fairly simple way, but a fairly effective way. Carroll preferred what he called the remuneration of services criterion, what we would nowadays call the strict risk distributor. Okay, so all the modern tax planning was sort of envisaged in this report in the early 30s. So if you had a sales office, Carroll said we should just treat them as selling on commission. So they get a commission, but everything else goes to the head office. Okay, so a lot of the selling profit would go to the head office on that approach. And that was the approach that Carroll favoured. And essentially all the business restructures and all the risk stripping, that's exactly what it's about. Changing from the sale between independents to the remuneration of services, and because you've stripped the risk, it's a very low cost plus remuneration of services in the strict risk distributor. So Carroll got his way effectively. I mean, it took us until the 1995 transfer pricing guidelines where functions, assets and risks became important in the transfer pricing analysis. And then people realised, well, we can play games, particularly with risks. Who has the inventory risk, which is what a strict risk distributor is dealing with. And essentially we now have in most cases a remuneration of services approach, which has significantly reduced the amount of profit that's taxable in the country of sale. And of course that's the big debate with Google and everyone else. The country of sale wants something. We are going in a direction in the last 20 years where the country of sale is getting less and less and less, even with a traditional business. Okay, so Google is not necessarily all that different, as we'll see as we go along. Let's check. Okay, so although there was common language, there's never been international agreement on exactly how you apply these principles. And if you look at the OECD attribution work in the 2000s, that's just created complete schism around the world about people who use the 2010 model and commentary, the 2008 model and commentary, or if you're a UN devotee, you use the 2008 model but the 2005 commentary from the OECD. So we're all over the place. Notwithstanding the pretty common language, and the same has continued through the current BEPS work. You'll still see these tensions in that work, but we'll come back to that. So those two things, just to give you a bit of a sense of the history, and that there was pretty consistent agreement on the threshold issue. There's been much less agreement historically on the allocation, how much, if you pass the threshold, how much gets taxed in either place. So let's focus back on that first question. Why did we use this threshold? What is it trying to achieve? And essentially it's in the old world of goods, no services, no digital economy, it was essentially a difference between export and foreign direct investment. Okay, this was expressed to, so if I'm an Australian miner and I'm selling heaps of coal and iron ore to India, which I would be, nothing, they don't have, they don't do anything in India. It's all done in Australia. They put it on the ship, and at that stage it's owned by the Indian firm who's bought it. And so to say India should tax in that scenario, Australia's not going to go along with that for sure, just because someone here had the money to buy the coal. All of that coal was Australian, was produced in Australia, it was simply exported to India. Nothing more happened. On the other hand, if one of those companies comes here and sets up a mine, completely different story. Okay, now it's foreign direct investment. They would need to get all the approvals you need for foreign direct investment. So your foreign direct investment law recognises this distinction. You don't need to get Indian government's permission to trade with Indian businesses. Okay, but you do need to get their permission to enter the country and set up business here. And the permanent establishment and local subsidiaries is kind of the test that we use to see whether you've gone into foreign direct investment. If you look at the way foreign direct investment statistics are prepared, that foreign direct investment laws are written, they use the same concepts. Okay, they're the concepts they use, and they, in fact, if you look at the statistics, they actually are often derived from the tax office. So that they're using quite often the tax test, even though they don't tell you very clearly in the statistics, they're actually using the tax test to see whether you've crossed the threshold. And I think that's certainly in that world of essentially international trade in goods, which was the traditional form of international trade, it was a quite sensible, easily applied and fair kind of approach. That the country only got to tax when the business was here and it was actually doing something substantial. And that's what the distinction is trying to express. It was originally expressed through the permanent establishment principle. In the case of subsidiaries, it's expressed by the kind of residence principle. If the subsidiary is resident here, then it will be treated as foreign direct investment, just as if there's a permanent establishment here. The difficulty in the modern business environment that this threshold now is being tested in a variety of ways, and it's not just in the digital space where this is happening. Collective investment. So collective investment is where a lot of small investors pool their money and they've got a manager who invests it for them, and they may invest in Tata and all the big Indian enterprise. I don't know whether you can invest in Tata or not. You can? It was listed. So they will often have local advisors, they may even have a representative office here, but it's all portfolio investment. Okay, it's all portfolio investment. We're talking about the investors, not the firm who's managing the investments. If they set up an office here and do a lot of activity here, sure, we can tax them on their profit that they make from their activity here. But can we tax the investors? Well, depending on the structure, you can create permanent establishments for all the investors, and it's not very sensible to say they are direct, in some sense, that foreign direct investment in India, because they happen to be attached to have a manager who's managing the whole pool of funds. And you'll find a number of countries, the US, the UK, amongst many others, actually have special rules for that kind of situation to say, no, we're not going to tax all those investors, because it would be crazy to say just because they have an agent who is buying and selling on their behalf, that means that the little person sitting in Australia or wherever who owns a few shares indirectly in an Indian enterprise, that somehow or other they should be exposed to tax like a business. Okay, so that the collective investment doesn't receive as much attention as it should, but it's becoming more and more important. And the permanent establishment threshold works very badly for collective investment. Now, I'll give you that example because just to show that it's not a digital sort of phenomenon only. It's just the way businesses change, the way people, investors change. Private equity equally. Okay, private equity is more concentrated. You have fewer bigger investors who buy an enterprise or have again an advisor who buys the enterprise, tries to dress it up and make it run more efficiently and then sell it for a substantial profit. Are we going to treat those investors as doing business, or are we going to treat them like the little investors in collective investment? Okay, you see, you're starting to get closer to the line. These people are sophisticated, but they, in fact, are quite passive quite often in the way they operate. I don't know in India, but in Australia we've had a lot of contention publicly about the tax treatment of private equity investment that's coming into Australia. So I start with those two to kind of make the point that this is not just the digital economy. Okay? So what's different about the digital economy? The question is, well, what do we now mean by presence? Okay, it used to be easy. You couldn't sell goods in India unless you had a shop or an agent here. Okay? You needed someone on the ground to actually do it for you. The difference with digital businesses, at least conceptually, when you look at most digital businesses, they're not too different, in fact, from many old economy businesses. But at least conceptually, they could operate completely remotely. Okay, so the nearest you get to that is buying digital books, digital music, digital films direct from a foreign website, iTunes or Amazon or wherever. Okay, that sort of is the kind of possibility which is driving a lot of this. But if you actually look at all of these businesses, they in fact have hordes of people on the ground in the country. Okay, so all the Indian Amazon Indian Google advertisements, how do they get onto Google? Well, there are marketing people here that Google has who goes around beating the bushes, getting the business. Okay, so Google doesn't operate completely remotely. Again, I haven't driven around the centre of Mumbai much, only came in this morning at 10 o'clock, so I've driven from the airport to the hotel and back here. But I assume there's probably an Apple store, maybe an Apple store here that is owned by Apple. Hey? Yeah.
Franchise model.
Yeah, okay. And so they, they've got huge stores on the ground. When people say, oh, this is a digital business, I go, what's that huge shop down the road selling all that hardware? Okay, so Apple doesn't operate in the digital sphere. It's got businesses on the ground everywhere. Amazon, there are still funny people out there. They tend to be younger people rather than older people. In my experience, all the old people are the ones who read on a tablet. Younger people, a lot of younger people still read books. Okay, so if you still read books, you like the feel of a book, then Amazon has to have a warehouse here that sends you the book, because that's their business model. We'll get it to you instantaneously, more or less. That's why they've been so successful internationally. And that means they need a big presence on the ground to the extent that they're selling books. So we'll come back to that, but the kind of characterisation of the digital business as all being in cyberspace is just not realistic so far as it's concerned. Okay, so let's turn to the theory of the firm. Okay, so why do M&Es exist? Why isn't the whole world like the marketplaces in Mumbai? Okay, where you just go down, you walk around, everyone's got their tomatoes or whatever, and you go and sort of look at the best price, and maybe the grower, or they'll only be usually one step removed from the grower, and they will sell it to you. And it's completely, there's more or less no business in the middle. Okay, there's just sort of direct. Everything's done directly between humans. Well, M&E, multinational enterprises exist because they can make more money by bringing everything in-house. Okay, you get the difference between a disaggregated market and a multinational enterprise is that within the enterprise everything is command and control. It's the Soviet economy. Okay, they tell you what to do. and how much to produce and what to produce, because they think we know what people out there want. We can do it more efficiently by keeping it all in-house. And the kind of choice businesses have to make between insourcing and outsourcing. How do they make that choice? They make it based on whether they can do it more cheaply in-house than outsourcing. If the market can provide it more efficiently, they go to the market. If they don't think the market's giving them a good price, they think we can do it inside and we can make more profit. We can sort of take the excess because the market's not very efficient. And that's essentially why businesses exist, because they can generate more value than the market is able to generate in a disaggregated form. So the question is, well, why can the market not just solve all of the problems? We're all now told to believe the market is the God, the market is the wonder. Why does the market not work inside a multinational? Well, there are a number of reasons. One is transaction costs. Okay, if you're buying tomatoes, go down the market, walk around, you see the tomatoes, you can see pretty clearly what's the best price. You can discover the price of tomatoes pretty easily. Once you get into beyond tomatoes, the cost of discovery of prices becomes very expensive. Okay, so if your firm said we're going to outsource everything, then they've got to go around and find the prices. And tomatoes, that's easy, but for many other things, it's not so easy. So one reason, and the original reason, so the theory of the firm was first posited by Ronald Coase back in the late 30s. Although Mitchell B. Carroll was clearly sort of aware of the same kind of thinking. He knew that firms were different. And he was quite clear that when he had his remuneration criterion, remunerations of services criteria, that the residual profit, there would be a residual profit, and it ended up in the head office. Okay, he was quite explicit about that the firm generated additional profits, and that was going to be taxed to the head office. But it was only in the late 30s that there was an articulated theory, economic theory of the firm by Ronald Coase, and his theory was transaction costs. Once it becomes too expensive to discover the market price, you're better off bringing it in-house where you can control it. You go out and hire people to do it for you, and you don't have to worry about what the market price of the service they produce is, because you know how much you're paying. Secondly, intangibles. Okay, intangibles depend a lot for their value on people not knowing enough about them out there. Okay, so if you patent something, you have to tell everyone how you do it, and then everyone will try and work their way around your patent. And therefore you keep things secret. You try and keep it in-house, and you don't let it out. Okay, so that's why most intangibles stay within the firm. You don't go and say to other firms. Google doesn't go to other firms and say, "Oh, we'll let you use our algorithm. Just pay us a license fee." Because then the people will know what the algorithm is, and Google will have lost all its value. Okay, so the intangibles require, for their value frequently, to keep it close to your chest, keep it protected. And that's why, again, you need a command and control environment to develop and use fully the value that intangibles generate, that research and development and all the rest generates. The third thing is entrepreneurial skills, scaling up entrepreneurial skills. Imagine if Steve Jobs was in one of those markets in Mumbai. Okay, he would never have scaled up to Apple. Okay, you need a firm, the entrepreneur who's got a good idea and wants to exploit the idea for their own profit. They need the command and control apparatus to do it, and Steve Jobs was notoriously a command and control person. Okay, he was very sort of like that. So that entrepreneurs, successful entrepreneurs, typically surround themselves with a big sort of apparatus that they control, because they're good at making money, and they can't make it all on their own, so they need to have an apparatus around. And in all those cases, you end up with, if the firm exists and is successful, its success indicates that it is actually generating additional value than could have been obtained through a disaggregated market. And the residual profits, an arm's length transactional principle, which depends on market prices, if you can discover them, and that's the big problem with transfer pricing, of course. So no one can discover the prices for transfer pricing. The very reason the firm exists is what we try and do in transfer pricing, which is quite bizarre in many ways. You've got a real price discovery problem with transfer pricing. So there's a residual profit, and the arm's length rule doesn't tell you how to allocate. Okay? It doesn't sort of, we've got profits over and above what market transactions would produce. We then posit a lot of market transactions and allocate value on that, but there's going to be something left over. And that's sort of why the permanent establishment threshold matches pretty clearly onto the policy. Its current expression, that's another matter, but the actual idea maps reasonably well onto the policy. Transfer pricing, I don't think maps to the theory very well at all, because it's using a disaggregated market paradigm to apply to an animal which exists because the disaggregated market doesn't work as well as it works to produce additional value. And so the consequences of that are there for everyone to see. Generally, the multinational is completely tax indifferent to the form of internal transactions. Okay, is it debt? Is it equity? It's money. You know, oh, we'll badge it debt. That makes it, we have less tax at source than if we badge it equity. Is it a sale? Is it the license? If we're talking about intangible property, who owns the intangible property? The firm is completely indifferent as to which company in the group owns the intangible property, as long as the firm owns it and controls it. And then whether they use a sale or license is, again, they're completely indifferent. All that they care about is the money they make from the outside world. The money they make internally is completely irrelevant to the profitability of the firm. It's just how they move the money around the group. That's all that's going on. So you have that tax difference. But also you get, because the firm is different, you get a lot of transactions occurring within firms that wouldn't occur between external parties. So just to take some form of intellectual property, which you might be prepared, and I'm not saying that there's no intellectual property which wouldn't be licensed to third parties. There may well be that. But if you do it, both parties do it in a way which secures their interests. Okay, so the owner of the property does it in a way which gets the maximum return, which will often involve an equity upside, profit upside. In addition to just a license fee, you sort of base some of the return on the sales that the other party makes. And it's for on the other hand, the recipient wants to make sure they're guaranteed. If they're going to spend a lot of money exploiting this intellectual property, they want a guaranteed period that they're going to be able to exploit it. So you'll have often an exclusive license, relatively long term, in the real world. With multinationals, that doesn't work very well internally, because they want to control. Those transactions have consequences as to who can sue for breach of patent, for example. Okay, so when you have an long-term exclusive license, it's the licensee in most countries who has the right to sue for the breach of the patent, not the licensor in those kinds of cases. A multinational needs to keep control, and what you'll find typically for licenses within multinational groups, they're at will. okay, because they want to keep control and have flexibility, and they don't want, so they try and concentrate the enforcement of the IP in a particular area, and they can't therefore give a subsidiary a long-term exclusive license, because that would be effectively diluting their power, even though it's all internal, to have that central control. So you'll find a lot of transactions occur within multinational firms that wouldn't occur externally, often for tax purposes. Okay, so that's the sort of the policy, and as I've already said, but just to repeat, the permanent establishment, the idea, concept seems to have some sense in it, that countries normally shouldn't tax just because someone is selling products into the country. It's only when there's a presence that carries out that selling or is involved in that selling that the country should have taxing rights. That's, people will probably want to debate that, but that's the idea, and it's an idea which exists in various areas of the law, foreign investment law being one of them. And in the case of transfer pricing, you've got this constant tension, because the rules have never ever reflected the theory. There's never been agreement on the theory, and in particular, when you've got a firm, you're going to have this residual profit, and it's not being allocated by the transfer prices, okay, the market prices, because you're applying a concept which is not meaningful to the firm. So it doesn't surprise me that we have difficulties with the outcome, and a lot of disagreement with the transfer pricing rules. Okay, so what are the modern tensions? I've already kind of indicated some of this, but I'll just go through it in a little more detail now. The OECD itself is quite frank that it's possible to have a permanent establishment which is part of a very profitable activity. So I'm not talking about cases where there may be business losses occur, real business profits being made. But they say that there'll be very little profit attributable to that permanent establishment. Okay, so because the risk has been stripped out of the permanent establishment. Contract manufacturers, strict risk distributors, so you can have a permanent establishment or a subsidiary and have very little profit left to tax. Even it's possible to have a lot of profits in a country without a permanent establishment. The commentary in relation to insurance, the commentary on Article 5, the permanent establishment definition, has said right from the beginning that insurance companies can operate in a way which doesn't require a permanent establishment, and they can be making lots of profits, have lots of people in your country, and yet you can't tax them. Okay, so the UN has a specific provision to deal with the UN model as an insurance permanent establishment, specifically to deal with insurance. So it's long been recognised right from the beginning of the OECD's work on permanent establishment that it was possible to structure yourself not to have a permanent establishment. And we'll come to insurance in a little bit, but just go through some of the activities. The fragmentation of activities is a simple way of avoiding permanent establishments, having lots of subsidiaries. Even say when you've got time thresholds, as you do for construction sites, for services, permanent establishments, and other kinds of permanent establishments. In some treaties you have time thresholds. You just split the threshold. You should have one subsidiary be there for a month, then another subsidiary for a month, another subsidiary for a month. You never cross the threshold. Okay, so now you'll see treaties who say, oh well, if they're all associated enterprises, you aggregate the threshold, so that you say, well,
the subsidiaries, one or other of them had a permanent had activities there for a month. There were 13 subsidiaries are over the 1 year threshold. Okay, so we actually have rules and treaties now which does that, and that sort of goes back to what I was saying before. Originally, that fragmentation didn't occur, but nowadays it's par for the course, and it's the big problem. To fix it, we have to go back and have that rule not just applying for time thresholds, but applying for all the activities that the multinational has in the country. So if we look at all of those activities and there's enough there to be a fixed place of business, then all of the business is present in the country, not just the company who has the office, but the whole group. Okay, so that's one of the problems. The method of doing business also is an issue, and so that's why we get all the commissionaire structures in Europe. You can artificially avoid the agency permanent establishment by using a commissionaire structure, or in India and Australia the equivalent there is the strict risk distributor. The distributor doesn't, because the distributor owns the inventory, they don't constitute a permanent establishment, but they don't take the inventory risk because of the arrangement between the distributor and the parent company. And there's something missing on the slide there, but it leads to the separation of the location of profits and activities. Okay, the permanent establishment threshold is not now a good measurement of activities that the MNE has in the country, which was its original purpose. It was a measure of when have you got enough activity there as a firm, as all of your subsidiaries and activities, to say you're no longer just selling goods to the country, you're actually operating there. And so to fix it fully, you would need to make it operate on a group basis, I think. That is much more radical than the OECD's like to be. And therefore we get this situation very commonly, lots of profits, no permanent establishment. It's a lot of activity. India is regarded, not surprisingly, as very aggressive in finding PEs. There are some hair-raising stories about when your revenue officials find a permanent establishment, even when there's hardly any or no activity at all, but kind of, I think in a sense that pushing the border is represents the frustration that the rules no longer map to the policy, and you need to fix the rules. So let's look at insurance first and then digital businesses second. So how can an insurance company structure itself so that it has lots of people in the country but no permanent establishment? Well, if you look at the two recent Canadian cases, Knights of Columbus and American Life Income, which concerned American insurance companies operating in Canada, they had, in the case of Knights of Columbus, about 200 field agents, people selling insurance. Okay, so they weren't it wasn't a small operation. They were out selling stuff and generating quite a lot of profit. But although they were called agents, they had no authority to conclude the contract because the underwriting quite genuinely was done in head office. Okay, so if you're selling life insurance, the way you make money, sell any insurance, is you don't sell it to people who you're going to have to pay out to. Okay, so you don't sell life insurance to someone with a terminal disease, for example, because you know that's not a very good bet. Even though they may only reject a small percentage, which was the case in this situation, Knights of Columbus, it was only about 2% who they actually rejected. That 2% probably was where they made most of their money. It was picking the bad bets and sort of not offering them the bet, essentially. And that was done in New Haven, Connecticut, where the Knights of Columbus. The Knights of Columbus is an interesting Catholic lay organisation. But you had to be a member of the Catholic Church to be a field agent, and you could only sell to Catholics. So I'm sure that breaches some discrimination laws or something. but that's how they operated. So they used to go to church and sell the stuff in church. That was literally they did it. They all had home offices. The insurance company had no office in Canada. It had, for regulatory purposes, they had to have a designated person who was a partner of a law firm who did all the regulatory filings, but he was an independent agent. And then all these field agents who weren't independent, but they weren't signing contracts, and therefore didn't have any power to sign the contracts, and therefore there was no agency permanent establishment. So they were making millions of dollars, had lots of people on the ground, and it's just a sign of the rules not working. Simple to fix. You just put in a rule which says if you've got people on the ground covering risks in the country, it's a permanent establishment. That's how the UN fixes it. And you'll see a not insignificant number of treaties have those provisions in it, but it's never been in the OECD model. Now I come to the digital businesses via the insurance business just to sort of think about, what actually is the nature of the business. I've already said, when you look at them, in fact, they often have large sales forces or people on the ground. So Google has people on the ground, Amazon has people on the ground, Apple has people on the ground. And yet when you look at what they do, they're all quite different. But if we said it, the test is a test of people on the ground and activities being carried on, I would say, well, clearly they've got a permanent establishment. They're carrying on business in the country, going back to what the original concept was about. The original concept was designed for sale of goods. It just didn't work as well for other kinds of things. So if you think of Google, they have all those people marketing too. So so my university, if you Google law schools in Australia, you'll get a Sydney Law School advertisement comes up. Okay, because we pay Google a lot of money, and they have someone who looks after the university account on the ground in Australia. But that's the way they work, but they don't contract. You always contract with the Irish, or I think it's Irish in Google's case. You always contract with the Irish subsidiary. That's been in the press. When you look at the substance of it, and this has happened in the UK in the parliamentary hearings, although the OECD is always saying, what they're doing is quite legal, etc., I think they probably cross the line frequently anyway. The marketing people actually sign the people up. They just say, you've got to send this form off to Ireland and get a stamp on it in Ireland, but essentially they're signing them up. So they probably already have that. If the revenue authorities wanted to push, they could argue, and some countries are now arguing that Google has a permanent establishment through the marketing people. Okay, so that's Google, and once you say that, seeing as they're making most of their money from that advertising, yes, the algorithm is very important in it, so you wouldn't say all the profit on those sales by any means is in the country, but you wouldn't say there's none of it in the country, which is what the current position is from the advertising. So Google is selling advertising. Apple is selling hardware and digital products. Okay, so the hardware, they have the shops on the ground who sells them. They're typically strip risk distributors, so they have very low cost plus kind of structures in most countries. So the people who sell you the iPhone and the tablets and the computers, they are paying a bit of tax on that, but not much, because it's all the risk, all the inventory risk is stripped out in various ways. And then the people buy the things, and then they start downloading apps like mad, and music like mad, and paying amounts to do those downloads. And that's clearly all coming remotely. Okay, you go into contact a website somewhere else in the world, and that's where it's delivered from. But when I look at it, I say, well, you know, it's a business which has two parts which are completely complementary. Selling the iPhones, etc., they make lots of money on that, but they also make lots of money on the follow-up sales of the digital products, the music, the apps, and all the rest, to the extent that you have to pay for them. Young people never seem to pay for them, but old people like me do. I think some of the profit from the digital sales clearly belongs with the shop, because it's a complementary business model that we sell you something which generates all these other sales. So not only do we not tax much of the profit on the phones and things, but we tax none of the profit on the digital products. Whereas I think we should be, countries would have a plausible argument under reconfigured rules. I'm not suggesting the current rules statute. But that would be my kind of approach to that business model. So, well, you can't just treat these two sales as completely separate. You should treat them as complementary, and that some of the profit on the digital products, in fact, is made by the shop, which sold the phone in the first place. Amazon, again, its business model depends upon that rapid delivery. So to the extent they've got a warehouse in the country, it's not just a warehouse which, you know, just storing goods and delivering it. If you ever see, there are programs on UK TV about the Amazon warehouse in Wales, you would never want to work there. They actually keep, it's all robotic, but there are people there working it, and they have cameras on you all day to see how efficient you're being. It doesn't sound like a very pleasant work environment, but it shows you how central it is to their business model, that they've got to get that stuff out of the shop to your door next day, and they've got all these systems in place. So to treat it as kind of like a traditional warehouse is just missing the point. But that's for tax purposes how it gets treated, and again they either get taxed on a low cost plus, or depending who owns it, you could even argue there's no permanent establishment at all. So it's problems in the permanent establishment rules, I think, or the way that tax administrations are often, India aside, not very aggressive in trying to enforce them. That is the issue, and but you won't see in this discussion that there's very little discussion of what is that fundamental policy. You know, we've got people on the ground doing stuff. That should create a taxable presence. If you go back to that, which was the original idea of the permanent establishment concept, if you go back there, I'm not suggesting we will, but I think you could make the rules work, the permanent establishment rule work quite well, and you know, effectively you would be deeming subsidiaries to be permanent establishments, or the activities of subsidiaries to constitute part of the permanent establishment that exists in the country. You would group all of the activities of the MNE. You wouldn't segregate them into the separate entities to test the threshold. Now, of course, this is not what advisors usually want to hear, but I'm just sort of trying to talk in the larger policy sense. And then so that's the threshold issue and the tensions that have emerged, and that they're all tensions that have emerged through problems in the rules which originally weren't a problem but have become a problem because of the different way of doing business nowadays. If you fix the threshold, however, you may expect a behavioural response from the firms. Okay, so Amazon may move its warehouse to Ireland from Wales, for example. Okay, it's about the same distance from much of the UK. It's not going to be too difficult to operate. Google might just pull its people out of the country and use a call centre or some other method of actually trying to market the advertising. So that's when you come to the sort of the hard bit. But I don't know that it's something we need to deal with yet. That if you've got someone who has a virtual presence in the country through its website and all the rest and accessibility, and is making lots of sales, are we going to say that's enough? And that's really where I'm sure that the OECD is not going to go at this point in time. Okay, they're going to fix, and probably not in the sense I've been indicating, at a much lower level, the permanent establishment threshold, rather than changing the whole model entirely. Because then it would become, I think, very difficult and require a lot of work to work out, well, exactly what are you going to tax and how. Anyway, the other tension is the one that I indicated earlier, was the measurement issue. How much, let's assume we think there's enough presence there, how much profits are we going to allocate? And this is one where I think at the end of the day we may end up with more progress than we do on the permanent establishment threshold, because there's always been dissatisfaction with transfer. There's always been this underlying problem that countries went along with it, but they were never fully happy with the results that it produced. And if you look at the OECD work in recent times, so 1995, the transfer pricing guidelines, and then the early work on attribution of profit to permanent establishments that the OECD did in the late 90s, was really the high watermark of going to Carroll's kind of view of the world, that the profits, the residual profit really belongs in the head office or wherever you want to put it, and that you'll only really have a remuneration of services criterion operating in the source country. That's where we've effectively got to through all the business restructures. You now have a small cost plus for many activities being conducted in the country. And yes, the activity is being recognised, but its significance to the generation of the profits of the firm, I don't think has been recognised. The OECD at the moment is in a sort of a schizophrenic period. Okay, so when you read the work coming out of the later attribution work on permanent establishments, the business restructures work, and now the base erosion and profit shifting work, there's the kind of schizophrenia. They still want to stay with this functions, assets, risk view of the world. Okay, and that's where I think they've made their big mistake. Risk, so far as the multinational is concerned, belongs to the whole enterprise. Okay, if something goes really wrong, so when the iPhone 6 bends and all sorts of stuff happens, it's not the company who manufactured it or the company who happens to own it who's, everyone in head office saying it's all your fault. Of course, the whole of Apple is affected. And the most senior people are immediately on top of it, trying to fix the problem. So this idea that the OECD has propagated, that risk is what generates profit, and it comes out of the kind of Steve Jobs view of the world, the entrepreneur view of the world. They call them famously KURLA personnel, key entrepreneurial risk-taking personnel, in part 2 of the attribution report. So that idea of the entrepreneur makes all the money, and all they've got to do is identify who the entrepreneur is in the organisation, and that's where all the profit is. Well, when you look at who it is, it's not Steve Jobs. Okay, having adopted the entrepreneurial view of the world, they don't say, therefore all of Apple's profits are now in heaven because Steve Jobs is in heaven, and but he's the one still making the money. Okay, it's all his ideas that are still making, the ideas that he drove, that are still making the money. It's kind of these middle-level executives who seem to be the OECD's vision of the profit makers in the organisation. And I find that a very strange view of the world. I agree to the extent you risk is an issue in a business, and for lots of businesses, risk is not an issue because lots of businesses make their money out of monopolies. Okay, and monopoly rent, they're deriving economic rent, and the money will just come in. Okay, if you're Australia, which has got lots of coal and lots of iron ore, the money is just going to come in from India and China while they keep developing. We don't have to do anything to generate that money. And so the idea that there was someone who sort of brilliantly said, oh, yeah, well, we shouldn't set up a coal company in Australia 100 years ago, that's not a real view of the world. It's just how things have happened. So, so they're still clinging to that framework, which I find very unsatisfying. To the extent you say, yes, we think it is the people who make the money, and that's one of the themes that the OECD is running with in this area. And I don't think that's an unfair view of at least the risk-taking side of the profits. Profits consist of partly risk-taking, partly economic rent. The economic rent sort of is different from the risk-taking. For the risk-taking point of view, I can see it being attributed to people. But why we identify a few people in an organisation and say they're the risk takers and all the rest of the drones who hang around doing nothing is kind of a crazy view of the world. The firm is set up, it has all these people because it thinks they all contribute and are making part of the profit, and if we didn't think they were contributing, we'd outsource what they do to the market because we don't think they add anything. Okay, so the firm keeps in-house the people it wants to keep in-house that it thinks contributes to the real profitability of the enterprise. And therefore it seems to me their salaries, some of them get paid low salaries, some of them get paid high salaries. That's a fair measure of how important they are. You may not think it's fair, but at least it's a workable measure of how the profits are distributed. So why we don't just use payroll? If that's what you think is the way you should do it, by looking at the people and risk-taking, then you shouldn't try and identify the risk-takers. You should just say, well, who gets paid the most? Who gets paid the less? We'll just use payroll to allocate the profit around, because they all contribute to it eventually. And that's why the firm keeps them in-house and doesn't shuffle them outside. So you've got that line of work where the OECD is, if you read the intangible stuff, if you read what's going to be coming out in the near future, I've seen some early drafts of it, it's kind of more of the same but a little bit more muted. They haven't really changed their spots. But on the other hand, the schizophrenia is they are now realising, oh, we've gone wrong there in a variety of ways, and now we're going to move back. And just to give you two examples, but there are many more. In the work they did on attribution of profits to permanent establishments, they tried to apply the transfer pricing guidelines as fully as they could to permanent establishments, which previously wasn't the scenario. And instead of having transactions, because you can't typically contract with yourself, so instead of having transactions, you have dealings. Okay, and that's what they said. Yes, you deposit a dealing, and you treat that dealing as if it's a transaction, and you price it using one of the transfer pricing methods. But when it came to risk, what did they say? Risk follows functions. You can't have a dealing which moves risk within a single enterprise unless there is a real person who's managing the risk, who is dealing with the risk in the other place. So they went to an activities test. They moved in relation to, because with subsidiaries, that's one of the big games, is risk shifting by contract. Okay, you just have an offshore captive insurer, punt a lot of the risk into the captive insurer, and that puts a lot of the profits into that captive insurer. They're saying you can't do that with a permanent establishment. I think they should say you can't do that with subsidiaries. Okay, so that would be the kind of thing. That's going in the right direction. The risk is where the risk is, and you don't recognise these artificial shifting of it by contract. And the second thing is the BEPS work on intangibles, where although they can't get rid of a lot of their old thinking, they're sort of rejecting two key building blocks of the tax planning, that funding and ownership of intangibles does not entitle you to the full reward from the intangible. Okay, so if you look at the Google structure, all the R&D pretty well is done in the US, developing the intangibles. The profits all end up in Bermuda from those intangibles. Okay. Because they are owned by a Bermudan company under a cost sharing, cost contribution arrangement that has been set up, and it's been well written about now how that system works. And so, well, where did Bermuda get the money to pay for it? Well, Apple gave it to us. Google gave it to them. It just goes in by equity or wherever. Okay, so they're now saying ownership and funding doesn't do it. If there's going to be cost contribution, we're going to effectively look at activity, the people who do the research, the people who are involved in managing the research and all the rest of it. So they're moving, even though they don't take away the transactional framework, they leave the transactional framework in place, they just say, oh, you've got to put more of the profit onto the activities and less onto ownership and funding. And so that's another case where the full respect for transactions, this kind of worshipping of risk, is being sort of watered down, and we're saying, no, we'll go and look at activities. So I think that's heading in the right direction, because if the threshold should depend on activities, then the profit should depend on activities. It seems to me to be a coherent structure. Current structure is not so coherent. So just to this slide, and it will be apparent from what I've said that I think the fundamental thing is you've got to aggregate activities. All the activities of the group should be looked at in judging whether there's a taxable presence in the country, whether they're carried out by subsidiaries or whether they're carried out by personnel on the ground, and you judge the taxable presence based on all of those activities. I don't think the OECD is going to go there, and that's essentially abandoning the separate entity bit of the separate entity arm's length principle. So that's what I'm sort of in effect saying. You should look at things on a group basis, not on a per company basis, in judging whether you cross the threshold. And it would be the total activities being carried on in the country which would determine the threshold. I don't think they're going to get anywhere near that. So the two things that three things they've kind of signalled are commissionaire arrangements. Okay, so it depends what they mean by commissionaire arrangements. It's just an artefact of avoiding an agency permanent establishment. But if they say commissionaire structures no longer work in civil law countries, which are the only countries they worked in, they'll just all be converted into strip distributors, which will work equally well. And so unless they go after the strip risk distributor in addition to the commissionaires, they've got nowhere. And as far as I can see, it's not clear that that's going to be the case. The other thing is the preparatory and auxiliary threshold. As you'd be aware, it's structured with a number of exceptions, which the OECD has said in its revised discussion draft on permanent establishment 2012, are not subject to any preparatory or auxiliary overriding test. It's only the last two paragraphs which are subject to that. So they may either take some things out of the preparatory or auxiliary exception, or certainly at least they will make the exception subject to an overall preparatory auxiliary test, so that so Amazon won't be able to argue that our warehouse is just sort of a minor part of our business. It's a core part of their business, and therefore they wouldn't be able to get out. I'm not suggesting that that's relevant to Amazon directly, but it's that kind of issue. And then the third thing is splitting of activities. Okay, so they say we're going to go after splitting of activities, but it looks like it's going to be in a very narrow sense, like the thresholds, the time thresholds. Okay, not in the broader sense that I've been indicating of just looking at all their activities and saying, well, that's a lot, that's enough. There's a taxable presence in the country. So revision, and I suspect a fairly low-level revision, not a much more extensive revision. But that will mean the pressure will remain on the threshold. That the pressure is going to still be there, and ultimately that may lead to some further work of the BEPS kind. And then so far as the measurement issue is concerned, I think we're going to see a move away from transaction. Okay, we're already seeing it a little bit, but I think we're going to see it a lot more, and towards profit methods, and particularly profit splits. And they've already kind of signalled it, but they're finding it hard to articulate how they're going to get there. And again, the way that it's structured, that we're just going to redo the guidelines consistently with the separate entity arm's length principle, and then we'll have special measures when we don't like the results, because that's the way the BEPS project is working. Rewrite to the extent you can the transfer pricing guidelines to get more sensible outcomes, and then when the outcomes are still not sensible, you have a special measure to cut it off. I think they should just do it by rewriting the guidelines and sort of doing it in the guidelines, having a much more sensible approach in the guidelines. But the problem is it's the kind of poachers turn gamekeepers. The people who created the mess are the ones who are being asked to fix the mess, and they're the last people in the world who will admit there's a mess or who will know how to fix it. And that is the structural problem, I think, in the way the work is being done. It's all being done by transfer pricing. What the special measures will be, stuff on IP potentially, stuff on debt. There are a number of things which could be dealt with by special measures, but to make them effective, they're going to have the multilateral treaty or have to amend all the existing treaties, because they're conceding in effect that the current structure has problems, rather than trying to rewrite the commentary or the guidelines to say no, there aren't really any problems. But I think what it will come to the extent they do it through the guidelines rather than through special measures, will be a move from transactional methods to profit methods, and that it's already happening. If you look at APAs, they tend to be very much based on profit methods in a number of countries, and I think that's the way it will go. But I think it's still going to leave countries like India, China, and Brazil not happy. I think at the moment it's clear that China, India and Brazil are not happy with the current guidelines. I'm not sure to what extent. When I say India, I don't mean you necessarily, I think. Your colleagues on the other side of the fence are probably not going to be happy. But then it's going to be interesting to see what happens. The big thing that will happen in November, I understand, well, two things will happen in November. Remember the 2014 deliverables for BEPS were released ahead of the Ministers of Finance meeting. All this is happening in Australia this year, so it's all sort of got in the newspapers all the time, but maybe not over here. But it was all released ahead of the meeting of the finance ministers. The question is, well then when the heads of government meet in November, have they got any glory for themselves? Because one thing they're going to say is, oh, we agree with the finance minister, so they'll just say we support the BEPS results. But the two things that I think have been left over for the heads of government is there's going to be a much bigger push to engage not only India, China and Brazil, but all the developing countries. Okay, they're not just exposed for the bigger developing countries, and I don't like to develop developing terms, but that's what everyone uses. Singapore still pretends it's a developing country and you can get away with it.
No longer.
They don't believe it. But there's that's one thing. I think that there's but if they, it's one thing to say it. It means they're going to have to compromise a bit more on where they've got to at the moment. If it's going to be, if the politicians say that and the bureaucrats are going to give effect to it, it means there's going to have to be a lot more moving in the direction of not the same place as India, China and Brazil, but more to accommodate their interests. And the second thing, which is not to do with anything else, but which has also been going on, and nothing to do with this particular topic, is the work on the ultimate legal ownership of entities. That we've not yet seen how that's going to be achieved, but the FATF is going to produce its report in November, and there's going to be a big push on that front as well. But I think that first one, the developing country things, is directed to the third question there. They want to know what's enough that will keep people basically on the same page to the extent you can achieve that. So I think it's enough for me.
Yeah. You're actually 10 minutes ahead of time.
Yeah.
But I think what we'll do is take any questions which are there on the phone, and then I think we can probably take on the questions which are there from the physical audience here. Yeah, no, I think it was pretty interesting, because I think one of the questions which was on top of my mind was really, is there really a need for you to look at a revision or replacement, as much as whether it's more a question of pushing the boundaries as far as interpretation is concerned? Because I think one of the points that you made was that India is one of the countries which is sort of pushing the boundaries as to what constitutes a permanent establishment, whereas a lot of other countries may not really be pushing the boundaries. So is there a real necessity as much as to revise the whole model, as opposed to possibly trying to keep pushing the boundaries through judicial mechanism?
I think at least my answers to that is, I think countries can push the boundary a lot further, but as I've tried to indicate, I don't think the current tests are the right tests. So, and I think that's the problem people have with India, that you're pushing the tests, you're not pushing the principles. So our major telco has a cable which runs sort of somewhere near India, and the Indian revenue turned up one day with an assessment for them. So I'm told. Okay.
Even when you have the satellites above,
You can even tax Steve Jobs, And for me, that wouldn't be
Heavens above India.
That's not sort of carrying on business in the sense that I was talking about. And the same with the. That's why I put private equity and collective investment vehicles up there. If you push the threshold, you can bring in people you don't want to bring in, and still have to leave out people who arguably should be in. So I think for the current digital economy stuff, some of those structures, clearly the governments would go a lot harder on them under current treaties and current interpretation, and get a lot more than they're doing. And I think that's starting to happen. I think we're going to see quite a bit of Google under siege, Apple under siege in a number of countries, certainly in Australia. The government's been, not the government, the tax office has been quite public about they're looking at all these companies, not naming them, they can't name them, but it's pretty clear who they're looking at. And they're going to, I'm sure, raise some assessments either on the subsidiary by saying the cost plus doesn't cover, or even going for a permanent establishment and trying to tax some of the profit that currently has been booked in Ireland. So yes, they can do that, but my fear would be that if they just push everywhere, they'll bring in some people they shouldn't, and they'll still be missing out on some they should. That may be better than where we are now, but I know for collective investment, in the future is going to be the big source of investment funds, and if you have aggressive claims of permanent establishment so that all the little investors end up with permanent establishments, that doesn't seem a very sensible outcome as far as that I can see. My concern would be, we're going to miss the target. We're going to hit 70% of the target. We're going to hit some innocent bystanders, and we're still going to miss 30% of the target. But in the real world, you're never going to get perfect. So certainly more sensible enforcement and trying to fix some of the problems, I think is a good first step, but it still doesn't resolve the underlying policy tension.
Yeah, because at least one of the challenges that will be there is that even if you're looking at a revision, for you to get all the countries on board for a revision, we are probably looking at certain additional new products, because when digital has come in the last 5 years, 6 years, that it's really mushroomed significantly. So by the time you get all the countries on board, you're going to be looking at 3 or 4 other things which are probably the next big things that are going to come in place. So the law is always going to be 2 steps or 3 steps behind at all points in time. So which is where would countries be better off really for you to try and work around the existing law, because the moment you start trying to make changes and have everyone coming on board, well, you're looking at, let's say, a 4-year process.
Well, 4 years is not all that long. It took the OECD 12, 13 years to do the attribution.
Everything gets compressed.
I think my problem with sort of just trying to enforce stuff more is that because you don't give clear signals to the tax administration exactly what it is that they should be going after, they will go after everything, and not just India. We see it in Australia. We have quite aggressive tax administration as well. We will see it in Australia, and that produces a lot of angst, a lot of compliance costs, and says to me that we've got to be proceeding on both fronts. But whether you'll get it politically, they're putting a lot of eggs into the basket of the multilateral treatment. That's why I was saying the transfer pricing. Why don't they just try and fix the guidelines? Who can say what the arm's length principle really means? So if you read historically, from Carroll through
to now, the different guidance on transfer pricing, it's been very varied over that period. So why you couldn't, in that case, do it through the guidelines? Because then countries just pick it up. You don't have to change your law or anything. Whereas this rewrite but then have special measures, I think is exactly that problem. Will the measures get through? How long will it take?
But to what extent has transfer pricing really been successful? At least what we've seen in the Indian context has generally been that it's more a question of the data not being available. You don't have absolute access to data. Whatever is there in the public domain which people rely upon, I don't know to what extent there is any degree of accuracy between what really you're doing and what is there in the public domain. So to what extent does it really resolve the problem for you? Apart from probably giving you some degree of guidance, but is it really accurate is a question that's out there.
I didn't say it as clearly, but I think the direction they've been going in and they're still going in is doomed to failure. You know, the very reason the firm exists was the difficulty of discovering prices. We've got a rule which says you've got to go and discover the price, which is undiscoverable. That seems to me to be the core of it. So that they need to move. You know, they've got to. It's a good thing to test when the documents come out. Just see how many times they say facts and circumstances. Okay. As soon as they say that, that means it's impossible for the tax administration to do anything. Because and that's they've got. That's why I think they've got to go to profit splits and say we know we can't discover this stuff. We'll look for criteria which give us a reasonable measure for this firm, not global form reapportionment, but a reasonable measurement of the value generation of that firm, and then apply that. But I think they could do that under the guidelines.
That's and probably a more accurate depiction of what the actual profits are really should be attributed for each deviation. Any other questions?
Each country has its own views. India's views can be quite extreme. Right? So many countries have various views. But the way, and then you say that now you have these MNCs, you have the firms, they're artificial structures, abusive structures, and so in the whole debate, I think the sad thing is the firms, the multinationals are coming out as the bad guys. To put it very loosely, right? They're not the bad guys. They're the guys creating jobs for everyone. They're the guys creating wealth. Right? The problem has arisen because of countries are not able to come together. Right? So because governments cannot come together and have some consensus on how to tax, everyone else becomes a victim to that. The multinationals, the firms become a victim to that. Right? So should there be a general fundamental shift in the way people are looking at it? Where the idea is, let's say, the basic guiding principle: no one shall be taxed more than once. Right? A lot of these structures are suddenly irrelevant if one can ensure that you may be organized as a multinational, irrespective of commissioner or subsidiary or anything. You're going to be taxed once on your global income, wherever it arises. Countries fight it out, but that's why there are various concepts, and even EU having a consolidated tax base in that sense, and then even Nishith has a very radical idea about eliminating taxation itself and just have one world, one tax, where every multinational puts in some amount into a global escrow account, and countries fight for it, and divide it among themselves, while the multinationals continue to create products, create iPhones, and create jobs, and although everyone is happy, right? And lawyers will be engaged by the governments and other companies. So it's just
fees though.
Yeah, so it's just a matter of whether it's possible to do all this work, have all this thinking on these standards, where it's going, and not really, bringing multinationals in bad light, right? And focusing more on how to make it objective and easier and ensure that certainty and non-double taxation is the only guiding principle. Do you see that kind of a thing? Probably.
Well, I think really two points I think you're making. One is which is lost in this debate and which does concern me, which you make, which was saying these companies are the ones who are generating the wealth.
around the world. And so you've got to think what's the appropriate tax. So that's why we have tax competition. Essentially, you're saying do away with tax competition. That's one of the things you're saying. And I would like that to happen, but is it really realistic? And then the kind of other thing is sort of you've gone, for me, sort of up several levels of higher to say, well, we want certainty. You're only taxed once, but how do we achieve that? I mean, it's simply not feasible, I don't think, to say the firms will just put 20% of their global profits in a pool somewhere, and then the countries will fight over. But maintaining consensus is important. The OECD is, and the global tax generally, consensus is becoming harder and harder to maintain. And that's one of the things that is the responsibility of companies. They need to get consensus. I think you are going to get a lot more uncertainty about this. What worries me about the way the transfer pricing stuff is going. I mean, it's one thing to say ownership and funding don't count, and you say, well, what does count? And they're not very clear about that. Okay, I mean, we had a clear rule which didn't work very well, but at least you had certainty. The way the transfer pricing goes is they're just becoming a huge discretionary tax engine for the administration, because nothing is certain anymore. And that's why going down this facts and circumstances, it's all in the eye of the beholder, is, I think, very dangerous. And that's why going the other direction would have a greater chance of consensus and certainty, but they just don't seem to be going.
Richard, I have a comment, and I think it's the revision of the B threshold is something that will have to take place. So indeed, this is a unique opportunity to achieve some broader consensus in the world as to how low this threshold should be. One of the big differences that we have perceived, in particular with India and the position of tax authorities, which we see also reflected in the OECD model as an annex to the OECD model tax convention, is that the threshold is very low. So in other countries, the threshold is high. But now we all understand that the digital economy makes this threshold needing a revision. So perhaps if we made it to achieve some consensus in respect of fighting harmful tax competition, then we can also take this opportunity to lower the threshold in a way that will bring some kind of homogeneous or sort of harmonious standards in different countries of the world. Bringing the threshold down will go in a direction which is perhaps more acceptable for some developing countries, and perhaps that will simplify some matters. So, I'm quite optimistic about the developments, but wanted to see whether you also took a similar position, or you think that it's just a dream to approximate the concept of permanent establishment and thresholds in the world.
I think there will be progress, but I don't think the dream will be realised. Because it is, having worked at the OECD, even on tiny things, getting consensus is amongst, then 24 countries, now 34 countries in the OECD. When you add the G20, they're up to 44 countries. Then when you add more and more developing countries, getting consensus is very, very difficult. So, and it tends to lead you back to the status quo, or very small changes in the status quo, because they can't agree on it. They all agree that it needs to be changed, they just can't agree on the change. I don't know that I'd be as optimistic as you are. That's why I come back to the policy side of it. You read these documents from beginning to end, you don't see any of the stuff that I've discussed in any of them. Yes, they talk about uniting income and activities, but but otherwise about what is the PE threshold there for, and all that kind of stuff. No one, they never, it's only in 2008 that the OECD put anything of any significance into the commentary about where you draw the threshold when they put the optional services permanent establishment provision in the commentary. That's the first time. All they ever had before that was everyone agrees that the permanent establishment is the right threshold for determining when you're sufficiently engaged in the country, and that was all that they said so far as the policy was concerned, and that's what concerns me, that they don't. And remember, one of the actions, I think it was action 12 or 11, is about the policy underlying BEPS, okay, about is tax competition good or bad, or when is it good, when is it bad, all that kind of stuff. That work is being done at the end, not at the beginning. You would have thought they would have done it at the beginning to work out what we want to do. So, you know, I'm kind of optimistic about BEPS in that something is happening, but I'm not optimistic that it's going to create the ideal world, or that it's going to move things, you know, too far. And so that brings me to my sort of what I've been writing about recently, what happens after BEPS. There's at the moment no mechanism in place to even ensure that countries who agree to make changes make them. Okay, for exchange of information now, we have this huge apparatus in the Global Forum on Transparency. The only thing they're going to have at the moment after BEPS is the Forum on Harmful Tax Practices, which has been there for about 10, 15 years and has been completely ineffective. So we've got to believe it's going to suddenly become effective. And they're going to have the multilateral instruments, so they'll have to have someone who's looking after that, presumably the OECD. But that doesn't give them any power to do anything. All it does, it gives them power to get people to sign up. So there's no mechanisms yet being explored for, well, even to whatever extent of consensus we get, how do we ensure that it is carried out?
Are countries better off just looking at transaction taxes on digital economy rather than going after them on a permanent establishment?
No, it's but you know, the problem with that is that they can simply morph. You know, so how are you going to define what you're going to tax? It's always this kind of belief. In Australia, we had this crazy politician who always said, "Oh, if we had a tax of 0.01% on every bank deposit in Australia, that would produce as much money as the current tax system." And you'd say, "Yeah, but it would all be in Hong Kong."
Yeah.
So, you know,
the EU was also looking at having the transaction taxes on securities. India actually has it in place. It's been working for the last 5 years, 6 years, or 8 years.
Yeah, well,
It's actually been they have been recording a lot of money. It's been successful, but at least on transactions on digital economy, you just ensure, because the money has to flow through the banks. Ensure that there is at least a small percentage, even though you'll never catch them on permanent establishment.
You'll have a Hong Kong credit card.
That